Okay, anything else you want to yell at me about? Not what?
I don't want to have the same issue that happened last time I was here. And you asked Ms. Morgan to stay away from work. No.
Okay, hold on. Where is Miss Morgan here?
Yes, Your Honor.
Okay, you need to sit down.
Can I say something?
No. All right. So you need to get on the bus. Okay, stop for a moment. Miss Morgan, do you need to get on the bus?
Yeah, the bus have video, did nothing happen, I got off the bus.
Okay,
The bus has video, she's lying.
Court does call the case, People versus Sonia McLean. What?
She's here. I think she's in the lady.
I will, Mr. Brown. Thank you.
There she is. Come on. Good morning.
So you now want me to unpass it?
Yeah.
Okay. Court does call the case, People versus Sonia McLean. You got it? We clear in? On the, yeah, okay. All right.
You said, in first,
Oh, hi. Sorry, are you working?
Yes. All right. All discovery is complete.
that's the mission. May we approach?
This is B3.
There's no need to approach, well, Mr. Brown wants to approach you kind of, but, Mr. Brown has asked me, a couple times for any videos in this case. I've sent, multiple emails to YPD requesting any audio or video. They've probably unresponded to. So there may or may, I don't know if there is any video or not, but my requests for any video have gone unanswered. I have no issue with setting it for a PE. If something turns up, we'll cross that bridge and we get it.
You can dismiss it.
Well, I realize is there a reason to believe that there is video?
Yeah.
Okay, and the people have, you requested, Mr. Brown, people have requested a YPD and they just have not.
They're ignoring
I'm used to that, but.
I guess, Mr. Childers, to the extent that they're not, there's no response. Is that?
The response is not that there is no video, there's just no response.
Then if,
I suppose if the court wishes, I could, elevate my email to see if I email command staff, if they may respond, but no. It's certainly worth a shot. If we want, in an effort to keep the case moving along, I can stand until the end of September, and I can continue my efforts.
well, I don't know why it's one.
This is where experienced judges separate courtroom drama from courtroom procedure. Instead of delaying the case because discovery is incomplete, the judge creates a deadline and puts the responsibility squarely on law enforcement. That's a powerful reminder that prosecutors can't simply shrug when evidence requests go unanswered. If video exists, the defense has a legal right to see it. What do you think? Should police departments face tougher consequences when they ignore discovery requests?
If there's an issue getting discovery, this is a whole other realm.
Yeah.
Where they're not responding to a legitimate discovery request. And, you know, and I'm not trying to disparage any department, but the last time I ran into this was with YPD. And I ultimately ended up dismissing the case. All right, here's what we'll do. She wants to say something with her law degree.
Yep.
I don't think she does. The people around you are doing just fine. Okay? So here's what I'm going to do. I'm going to set so as not to impact the defendant's rights. I'm going to set the preliminary examination. Mr. Brown, prepare an order for my signature that directs that YPD is to turn over all video. I will set this examination for the 17th. Today is the 4th. So I'm going to need it right away so that there's time. But that they're to turn over all video to the Washington County Prosecutor's Office by the 11th. And if they then, that will go under my signature.
Notice what just happened. The judge didn't dismiss the case, but he also refused to let missing evidence slide. By signing a direct court order, he's creating accountability. If that evidence isn't produced now, the consequences could be much more serious, including sanctions or even dismissal. It's a textbook example of a judge protecting the defendant's constitutional right to a fair process.
That way, if they then fail to do what I'm ordering them to do, then the court will take appropriate remedies.
Your Honor, from a logistical standpoint, once that order is signed, would you like for me to send that order along to YPD?
Yes, please. Preliminary examination in this matter will indicate discovery is not complete, but preliminary examination in this matter will be set in person September 17th, 2024, 9 a.m. That will be before me. And then the bond will continue. Now, given all of that, ma'am, is there something you wanted to say?
She was trying to leave and go to the, get on the bus, and there was some contact, so we had to contact Pittsfield Police to make a narrative report that she was not in violation of any court orders. I have a copy of it if you'd like.
Hold on.
Just like to be able to get on the bus.
Hold on. You gotta catch me up because that was today.
No, that was the last time.
22nd,
22nd.
Mrs. Morgan, approach.
Just hold on. Okay, you're good.
You don't have. Your Honor.
So, well, I just want to make sure I'm clear. You got on the bus. You were, okay, but in any event, you ended up on the bus, right? All right.
Because Ms.
Hey,
Morgan,
but hold it, just hold it. Just hold on a moment, okay? And then at some point, the alleged victim in this case came into contact with her.
Yes.
As I'm to understand, based upon what you said, Mr. Brown, she then contacts the police.
She comes back here and asks for my advice. So
Got it. That's it. I don't want to know what you two discussed. But out of that, there then is generated a report from Pittsfield.
yes,
Got it. And so your concern, ma'am, is that somehow the court may try to hold you responsible for that contact. Okay. I have not seen the report. I do not think that I need to see it. Okay. I'm going to make a presumption as to the advice that Mr. Brown gave you. I think that that was absolutely appropriate advice. And should the issue arise, then I would review that report and I would take that all into consideration. All right. But at this point, I am not going to do anything. I don't have a complaint that you've done anything. And so I'm not going to make one.
This exchange is more important than it looks. The judge isn't deciding who's telling the truth about the bus incident. He's making it crystal clear that courts act on evidence, not accusations. That's how due process works. Instead of escalating emotions, he's lowering the temperature before a small misunderstanding turns into a much bigger legal problem.
Fair enough?
I need time to get on the bus again. Not leave out the courtroom and then get.
Okay. All right. Listen. Just listen. Mr. Brown gave you advice, okay, regarding a situation that you had, I guess, last time that you were here, right? So it would seem to me, would it not, that should you leave and that same or similar type of thing happen, that you would then follow the advice that your attorney gave you? And I kind of indicated to you at this point how I'm looking at it. Okay? I know it may worry you, but I think follow what your attorney is telling you. All right?
This is actually a great example of how experienced judges handle potential bond issues before they become bigger problems. Notice that the judge isn't accusing the defendant of violating the no-contact order or immediately imposing sanctions. Instead, he's making it clear that he'll only act on verified facts, not assumptions. At the same time, he's reminding the defendant that the safest legal strategy is simple. Listen to your attorney and avoid any situation that could even appear to violate the court's conditions. In criminal cases, especially when bond conditions are involved, even an accidental encounter can become an issue if it's handled the wrong way. The judge is trying to prevent another dispute before it happens, rather than punish someone after the fact. What do you think? Was the judge being patient here, or should he have taken stronger action immediately?
Okay, anything else you want to yell at me about?
I just want to have time to leave. Okay, you mentioned not have to get me something.
Not what?
I don't want to have the same issue that happened last time I was here, Your Honor. And you asked Ms. Morgan to sit and wait for it. No.
Okay, hold on. Where is Miss Morgan here?
Yes, Your Honor.
Okay, you need to sit down.
Can I say something?
No. All right. So you need to get on the bus. Okay, stop for a moment. Miss Morgan, do you need to get on the bus?
Yeah, the bus had video, did nothing happen, I got off the bus.
Okay,
The bus had video, she's lying.
And I'm going to presume you both take the same bus.
I don't have a
Okay. I wish you would stop yelling up here at me. Mr. Feaster? I'm not going to ask you to drive anybody, so don't tell me. No, I'm just, so, okay, here's the thing I do not know. And I'm going to maybe potentially embarrass myself. I have not taken a bus. Well, no, I don't, wow. But I just haven't. And so I know that when I get on a bus, or when I did, but it is so long, the dinosaur was pulling it. But anyway, it just took me downtown and I had to find another bus. And I just told myself I'm not.
You don't see this every day. The judge is literally creating a practical solution to prevent future conflict outside the courthouse. It's almost humorous, but there's real legal strategy behind it. By keeping the parties separated, the court reduces the risk of another alleged no-contact violation. Sometimes courtroom management is just as important as legal rulings.
I'm doing all that. So, that's why it's my limitation. How often do the buses come to where you would have to pick the bus up, get the bus?
Every 15 minutes across the street.
Every 15 minutes across the street. Okay, so here's what we're gonna do. Okay? This time around, you get the first 15 minutes. Remind me the next time, then you'll get the first 15 minutes, and then you gotta wait and take the next bus. Huh? Oh, so now you took up all my time, now you wanna leave? No, go, just go. That's what we're gonna do. You go, don't get up, Miss Morgan, do not get on that same bus. Do not get on that. That's fine. I don't want you both on that same bus.
Still approaching me and sending threats to me, Your Honor, and that is the process.
Then you report that to the prosecutor's office. They will raise.
I told him again.
Don't know how to change it, right? Okay, so I will just say this, Ms. Morgan, when it is raised before me in a proper way by the people, I will deal with it, much like I said I would deal with her issue. But right now, I want you to take the next bus. The next time around, you'll get the first shot at the bus, she'll wait. Thank you. Okay, hold on. Where's Brown? Oh, great. And there's Easto. Did you see Ron Brown out there?
He was heading to the park.
Oh, Lord. Okay, I just need to know that his client left. Could somebody?
He's going to the bus.
Who?
Mr. Brown and his client are walking from the bus stop.
They're going together. Oh, beautiful. All right.
I can't.
Thank you for your participation, Mr. Easto. See, you weren't here. So, can somebody just look out there, try to make sure they got on the bus, and then I can let Miss Morgan go.
This door is going to confirm that, Your Honor. Should be right there.
Thank you.
Believe it or not, moments like this reveal why experienced judges earn respect. He's balancing serious criminal proceedings while still keeping the courtroom calm, organized, and even lighthearted. That humor isn't a distraction, it's a tool to maintain control over an emotionally charged environment without compromising fairness.
Ready to call the next case. Court calls case, People versus Justin Walters.
Good morning to you and your staff, Lillian Diallo, P52036, on behalf of Mr. Walters, who is present to my right, very nattily dressed as well. Thank you for coming to court, looking like you're coming to court.
Well, how come you didn't step in and help me just, anyway, no, never mind. All right, you're requesting and you were just retained on this, counsel.
I filled out one of those very complimentary green forms that go very well with my outfit.
Why, you know, and we should have picked a different color. I'm just telling you. I know.
So Judge, we're just asking for a brief adjournment. So
Yes.
I can get discovery. If there's any digital video discovery, we can ask for that as well.
All right. 3 weeks, maybe? 2 or 3 weeks? What would you like?
So, let's see, the best time for me would be
The 19th would be,
Yeah.
all right.
what time?
I set it at 9. You'll get an invite indicating your time block that you're,
Okay,
all right?
no worries.
September 19th, 2024, 9 a.m. Bound will continue.
Very good. We'll just have that one today.
You do the same. So you gotta set it for the next block? Oh, okay, then I finished that block. Is the bus stop okay? So you go out there and check on the bus stop. I'm gonna take a break. Court is taking recess.
Today's hearing wasn't about guilt or innocence, it was about protecting the integrity of the legal process. From enforcing discovery rules to preventing unnecessary conflict between the parties, every decision was aimed at ensuring fairness before the case moves forward. Now it's your turn. Did the judge handle this situation perfectly, or would you have taken a tougher approach? Let us know in the comments below.
Although this hearing may have seemed unusual at times, it actually involved two important legal issues. First, the court protected the defendant's discovery rights by ordering law enforcement to produce any existing video evidence before the preliminary examination. That's a fundamental part of ensuring both sides are prepared and that the process remains fair. Second, the judge carefully managed concerns surrounding the alleged no-contact order without rushing to conclusions, choosing to rely on documented evidence instead of speculation. Rather than escalating a misunderstanding, the court focused on keeping everyone separated and avoiding future conflicts while the criminal case moves forward. With discovery still pending and the preliminary examination now scheduled, the next hearing will likely determine whether this case advances toward trial. If you enjoyed this real courtroom breakdown, be sure to leave your thoughts in the comments. Hit that like button, share this video with fellow courtroom fans, and subscribe for more fascinating legal moments and in-depth courtroom analysis every week.